Hey everyone, it's Dr. DeCubellis from Main Street Chiropractic. Today I wanted to meet with Dennis from Vanderginst Law Firm. He's a personal injury attorney. He also works work comp, but today we're going to focus on personal injury. So I wanted to invite him here to help answer some questions I know a lot of people have. So Dennis, thank you for being here with me today.
Oh, it's my pleasure. I appreciate it.
So first thing, I know the biggest thing I get whenever I tell a patient that comes in who's been in a car accident that they should get an attorney is they don't understand what the difference is between a personal injury attorney and your typical, attorney elsewhere. Can you kind of go through the differences for me?
Yeah, and actually, before I get into the differences, you mentioned something that's important to know at the onset, which is in most instances, my feeling is that if somebody's been in an accident or had an accident at home or somebody else's property, and as a result have injuries that warrant the attention of a doctor, a chiropractor, any kind of treatment provider, there's a good chance that it warrants the attention of an attorney as well. So the question, as you just raised, is, well, who do you see? An attorney is an attorney, right? And that's not really the case. The practice of law is a lot like the practice of medicine with respect to practitioners, meaning that there are general practitioners and then there are specialists who focus on different areas. So, for instance, if you are sick, you can feel comfortable likely going to your primary care doctor. If you have certain aches and pains, you might want to see Dr. DeCubellis or another chiropractor or someone along those lines. But if you have a specific injury, you have had a knee, some nerve damage, you want to see a specialist like a neurologist or a neurosurgeon. And the same is true with attorneys. There are attorneys who are great at handling a multitude and a myriad of legal problems. They're general practitioners, just as you can see general practice physicians in the medical field. And then there are specialists, as there are in the medical field. So personal injury happens to be one of those specialties. There are other specialists who may focus entirely on real estate law or probate law or criminal defense work or something along those lines. But personal injury attorneys, if they are truly focused on just the industry or the field of personal injury law, they can handle any number of personal injury types of cases and matters. So, for instance, in our law firm, we'll handle clients who've been injured in a car accident, a slip and fall accident. Perhaps they've been injured by a faulty product. That's known as product liability law. Perhaps they were injured due to the negligence of a treatment provider, medical malpractice or medical negligence. There are folks who are injured or abused in nursing home scenarios. There are also, you've probably seen on television, all of the commercials out there that discuss the instances where people are injured as a result of taking different pharmaceuticals or having utilized different medical devices. Those typically lead to product liability cases in a mass or class action. Our office handles all of the above, and those all kind of fall in that umbrella of personal injury law. Now, there are some personal injury lawyers who will subspecialize, meaning maybe they don't do medical malpractice. Maybe they don't handle class action law. Maybe they don't do product liability law. Maybe their comfort level is simply handling car accidents or slip and fall or dog bites or things like that. So you have to be very careful when you're looking for the right attorney to fit your situation. Make sure you're speaking with a firm or an attorney that handles the type of situation that you find yourself a victim of.
Yeah, and that's very important because you're hiring someone to represent you and you want the best possible representation you can get. You want someone who's an expert. So hiring someone who has never done a personal injury case before to be your personal injury attorney is just setting yourself up for disaster. It's like
Absolutely.
the worst thing you can do, because they've got to know how to talk to the insurance company. And if you know how to talk to the insurance company better than this attorney who's never done it before, then I don't know what
Then
to
come
say.
join us and go to law school and join our firm. You know, I want to be fair to those attorneys who have different practices. You wouldn't want to hire us to do your real estate closing or to defend you in a criminal matter. And that's not to say that attorneys can't handle these separate areas of law, but just via experience and education, you get better at certain areas if you are focused on one area. So, you know, we feel that we're able to handle anything in the realm of personal injury law. And by the same token, if you have a traffic ticket or you have been arrested for something, you'd want to find someone who specializes in that area of law.
Right. So let me ask you this. So let's say we've got someone, they were in an accident, they're injured, and they call you and they want to potentially hire you to be their attorney. What do you look for in that case to decide whether you're going to accept it or not?
And that's a great question, Doctor. It differs from firm to firm, because there are some firms that actually look for a threshold as far as what the perceived settlement value of a case is before they'll take it on. So for instance, some firms may say to themselves, you know, if the case isn't worth at least $25,000, we don't even want to look at it. We don't look at it that way. What we look at are two different things. We look at the liability scenario, meaning is fault evident there, or do we feel that we'll be able to prove that someone was negligent or responsible under the law to compensate someone for the injuries? And secondly, was that person damaged? And by damages, we're referring to the injuries. You know, did they have to get medical attention? What is the amount of the medical bills? What kind of treatment might they need in the future? Have they lost income? Will they lose income in the future? Have they suffered from pain and or disability? Is there any scarring or disfigurement related to the type of injury that they sustained? So we look at all of that, and frankly, if we feel that liability exists, even on the smaller cases, we're typically going to handle those cases for most of our clients. And I'll be very honest, you know, what we do in our firm, because some firms simply, as I mentioned, won't take those cases. We feel that everybody should have access to representation in those cases. Now, it's also, frankly, a great training ground for some of our younger attorneys who are eager to get in and mix it up, you know, with insurance companies who are being unfair to our clients. And so if we need to, we'll file suit on those cases. Now, most of the time, we try to avoid filing suit for the benefit of our clients and simply for the convenience and the ease of getting them paid through settlement if possible. But you can't necessarily expect to get full value on a case as far as the compensation unless you're willing to battle. And so that's one of the reasons why we will take some of those smaller cases, because we want insurance carriers to know that, you know, we will, if necessary, file a lawsuit and take the case to trial. And, you know, if you don't do that, if you aren't willing to take the smaller cases, they're not necessarily going to take you seriously on the larger cases. If you show that you're willing to fight for your clients on those smaller cases, they're going to know you're going to fight tooth and nail on those larger cases. And that gives us a better opportunity to get the case settled for full value rather than either being forced to trial or accepting something less than what is reasonable to compensate someone for the injuries that they've gone through.
Yeah. And two very good points you kind of brought up there. First thing is that when we talk about timelines, is there's a specific timeline with everything, and I'll get back to that. But the second thing is definitely when we're looking at different attorney firms, and especially when I look at attorneys to work with, or when patients are looking for an attorney, you don't want an attorney that will not go to trial if need be, because you're taking away half of the battle or half of the ammunition they have potentially against the insurance company, and you're just kind of handicapping yourself. Not that everything has to go to trial, but there just has to be that possibility if it gets there, because part of it is when someone's injured and they're going through treatment, we don't necessarily know exactly what percentage of improvement they're going to have at the end. And that's important to know, because that also tells you where to go with the case too. So that's really important. I've dealt with attorneys before that all they do is just settle. And if an attorney's trying to settle a case and you're a week into treatment, that's usually not a good thing.
Yeah, for sure. And that is an important point. When you are resolving a case, you have to anticipate what the future holds in store for that injured party, in addition to what they've already been through. As Doctor pointed out here, if they're still in the middle of treatment, it's not time to get the case settled. You have to understand what is going to come in the future. Now, having said that, there are some scenarios where what might otherwise seem to be a premature settlement would make sense, primarily when we're talking about limited insurance policy limits. So if, for instance, this is a significant case that's worth X amount of dollars, but you only have Y amount of insurance coverage from the person who's responsible, and they tender their policy limits, usually you have to resolve it for the amount of insurance coverage. There are exceptions in every situation. Certainly, if the responsible party has assets above and beyond the insurance coverage that they have, that's something that you can always look into to see if it warrants pursuing them outside of their insurance coverage. But you have to also be aware that depending on the scenario, in some situations, the responsible party can simply file bankruptcy and avoid paying anything over and above their insurance coverage altogether. Obviously, that's not necessarily applicable when we're talking about large corporate entities who are the defendants. If, for instance, if it's a car accident and the driver of the other vehicle was working, for instance, for a large company at that time, then that company is also on the hook for covering the loss. Or if you were injured as a result of a product, or injured by a slip and fall accident on property owned by a large retail outlet and they're at fault, well, then you don't have to worry so much about insurance coverage limits. But there are situations, just to be fair, where the cases get settled for less than what the value of true compensation would be, and that's when you either have those limitations as far as coverage or assets, and in some instances, two other instances that arise. One, if there are multiple parties, multiple claimants or plaintiffs, meaning that a lot of people were injured by the responsible party, and there's a limited pot of money to split among them all. That's another way in which you can be limited. And then, frankly, the one that we don't like to talk about, but it does happen, is when the injured party, the person that goes in to see the doctor or comes to see us to represent them, are to blame or partially to blame. And then we apply what's called comparative negligence, or in some states, contributory negligence, to determine what degree of fault can you apportion to each of the parties. In some instances, even if our client is somewhat to blame, we may still be able to get them a recovery to compensate them, but it might be discounted in a pro rata fashion based on their degree of fault. So these, by the way, are a lot of the reasons you want to have an attorney who does this kind of work representing you if you have the injuries, so that they're aware of all of these nuances in the law. Because most attorneys, the general practice attorneys and specialists in other areas, aren't going to necessarily know these things.
Yeah, definitely. And that's the whole point that needs to be kind of understood, is the insurance company is not out to help you. They're out to save as much money as possible. And just everything you just mentioned, that's something the attorney is going to be the expert in, and you shouldn't have to worry about, because even a person talking with the insurance company is a recipe for disaster, because they're recording everything you say, and they're looking for anything to use against you. So it's always good to have someone represent you, because now that's not possible anymore.
And I'm glad you brought that up, because one thing that I wish I could speak to every injured person before they make decisions as to treatment, as to talking to insurance companies, as to having an attorney represent them, and let them know, if nothing else, please, when you've been injured, do not give any kind of a recorded statement to anyone, even your own insurance company to begin with. At some point, you need to cooperate with your own insurance company, but you should be represented at the point in time that you might be recording a statement. But certainly do not give a recorded statement to the other party's insurance carrier or any investigators who are representing the opposite party. By the same token, don't sign anything. You certainly don't want to sign any releases. You don't want to sign a waiver allowing them to get your medical records. Now, what happens frequently is, first thing that happens after an accident is an insurance adjuster gets assigned to the file. So let's just use auto accidents are the type of cases that a lot of people are familiar with. So let's assume you're in an auto accident, you're rear-ended, you're not at fault at all, you suffer some injuries, and so hopefully you're going to go see Dr. DeCubellis and have him help get you fixed up. But and we'll talk about that, I'm sure, a little bit more. But at some point, the other party's insurance company is going to likely try to reach out to you, and they're going to want to tell you, hey, we need, before we can get this resolved for you, we need to get a recorded statement from you, and we need you to sign off allowing us to get your medical records and bills. Most of the time, they're going to make it seem, very reasonable what they're asking. But don't be fooled. They're not your friends. They're not there to pay you large sums of money. They are there to save money. Okay, so when they are asking for, bear this in mind, they don't need your version of what happened. They can get the accident report. They can speak to their own insured. So for them to tell you that they need to hear from you is not truthful, let's just say. It just doesn't have to occur in order for them to review liability. Okay, now they may say, well, that may be true as far as determining who's at fault. We don't need to talk to you. But how are we going to know what the extent of your injuries or your damages are without talking to you? Well, that's when they'll ask you for that waiver. But then what they won't tell you is a lot of times what they're asking you to sign will allow them to get your medical records from birth on, stuff that has nothing to do with the accident that you have sustained. And a good example of how this can be misapplied in different situations, I represented a young woman who had a similar accident. I think it was a rear-end collision. And as a result, she had back pain. And she had, unfortunately, before calling us, signed an authorization that allowed the insurance company to get all of her records. Well, it came time after she was done treating that we were trying to get the case settled. And we had a reasonable demand for settlement purposes, and they came back with a lowball offer that just seemed completely out of bounds. And so I was speaking to the adjuster, asking why this offer was so low. And he said, well, we're not going to pay for back pain that we didn't cause. And I said, what are you talking about? I mean, clearly this accident was the cause of her back pain. To which he replied, well, look at such and such medical records. And sure enough, he was referencing something in her medical records from about 8 years prior that was related to her carrying a child. She was pregnant, complaining of back pain, and he wanted to associate this pain in her back 8 years later, when she'd been asymptomatic for years and years and years, to her pregnancy. Outrageous. And that's certainly an extreme example of how, these things can really come back to bite you in the butt. But we were obviously able to move forward and eventually got that resolved for a fair amount. But those are the types of things that can and do often happen, and why you don't want to sign anything, and why it's always a good idea to have an attorney on board as early as possible. The other thing, and I don't want to belabor this, but what happens when, and again, in the scenario that we're talking about, an auto accident, what happens shortly after an accident occurs is the responsible party calls up their insurance and alerts them to the fact that there may be a claim made because of the accident. When the insurance carrier is notified of this, they have to do an evaluation early on to determine what's the range that we likely will have to pay in compensation on this case. And then the government requires them to set aside what are known as reserves, okay? So if they evaluate a case and they think that the value of this case is somewhere between $20,000 and $30,000, they're going to put $30,000 into reserves that they're going to, garner interest on for a while until they get it resolved. But that's the amount of money, that's the pot of money that they intend to have available to settle that case. If, however, it turns out that the case has a value of far more than those reserves, it is like pulling teeth to get the case resolved for value. Typically, you have to end up filing the case, getting a supervisor to remove the reserves or reassess it and put a different amount associated to the file. Well, the way that they evaluate these cases in order to determine the reserves is they look at the totality of the circumstances. What's the liability situation? What do we know about the injuries at this point in time? Another thing that they look at, though, is this person represented by an attorney? If they are, the reserves go from here to here. And if it's an attorney that knows what they're doing, because they track this, they know which attorneys do injury law, et cetera, it goes from here to here to here. That means you have all that space in which to negotiate when it comes time to get the case resolved. For that reason, again, you need to get somebody on board. And I'm not trying to solicit cases for banned against law. I'm trying to make sure that those people who are injured are being properly taken care of and get the kind of compensation to which they're entitled. And this is one of the things that you can do as an injured party to make sure everything is in order to get you the kind of compensation you deserve. So just make sure you're seeing an attorney who specializes and focuses on injury law in order to enhance the type of recovery you're ultimately going to be entitled to.
Yeah, that sounds good. And that's a big thing that people have to understand is with that too, there are timelines for when they need to hire an attorney, because paperwork has to be done. If there's going to be a lawsuit, it has to be filed by a certain time. But also there's timelines on when they need to actually seek treatment. They can't wait 2 months before they go to a doctor. I mean, there's no case there. So there's timelines, and that's why the quicker you get it done, the better you are. You can't do it quick enough.
Absolutely. And that's a good segue into what I kind of alluded to. If you are injured, and I don't mean to sound sexist in saying this, but I find this to be true with men in particular who try to tough it out. They're going to, it'll go away, or, I'll rub dirt on it or whatever. Don't do that. Get in to see the appropriate doctor. And in a lot of cases, it's going to be a doctor like Dr. DeCubellis, because chiropractic care, I'm a huge advocate of, especially when we're talking about soft tissue injuries, which you see over and over and over again in car accident cases, slip and fall accident cases, a lot of those types of construction injuries, et cetera. In a lot of those instances, the best and quickest results you're going to get come from chiropractic care. Do not hesitate. Some people are concerned, well, is the other party going to pay for these bills, for these chiropractic bills? The answer is yes, as long as liability exists and as long as the care and treatment is reasonable and necessary. And historically and experientially, I can tell you that chiropractic care is just like any other type of medical or surgical or other treatment care or care that can be rendered for an injury patient. As long as it is reasonable and necessary, it's going to be covered by the recovery you get from the responsible party. Okay, so and chiropractic care can just be the answer to your prayers if you have those types of injuries. And if you don't, if your injuries would warrant a different type of care, a good chiropractor is going to tell you. He or she is going to refer you to the appropriate treatment provider. Often what will happen is a chiropractor, and I'm sure doctor can tell you this as well, is they will take the care as far as they can, and as long as the patient is improving, that tells you that this is reasonable and necessary to address the injury. And if they stagnate in care, or if they determine that there's something structurally that they cannot address, or that they feel that should be reviewed, they'll make a referral to another expert, whether it's a neurologist, a neurosurgeon, an orthopedic surgeon. It could be any number of folks that will need to take another look. And that, again, is perfectly appropriate and is something that will be compensable, again, as long as there's liability and as long as the insurance coverage is there. So please don't, as the doctor mentioned, do not delay, because there needs to be a consistent and continual timeline. Put yourself in the shoes of the adjuster or the insurance carrier or ultimately a jury. If you've been injured and you fail to get care or treatment for weeks or months, but you still feel that ultimately you need to get treatment and then you start treating, well, the questions that are going to arise is, how do we know this injury that you are now treating for weeks or months later was related to that accident? How do we know that it's just not, your typical bumps and bruises of the daily grind, or that you didn't have another accident? There has to be there should be a timeline, a causal connection that we can look at. And medical records, chiropractic records are a great way to connect those dots for the adjuster or ultimately a jury if necessary.
Yeah, definitely. And that's a great segue to kind of talking about when we look at this from another perspective of, an attorney working with doctors and how that helps out the clients as well. First thing is that I always like to kind of say, you, the attorney, you get a case, right? And you get a case that comes in and it went to the hospital. There was nothing, they didn't find any hard tissue type issues, no emergency condition. They're in pain. They went to another doctor. It comes across your desk and the diagnosis is neck pain with a sprain. That doesn't tell you a lot right there. That's a pretty bad diagnosis. Or if you get a patient that comes in and we rule out all of the major things, they went to the hospital, there's no fractures, no concussions, no nerve damage, that's done. But upon examination, there's found to bear not only do we have pain in the cervical region, but through imaging and treatment or imaging and diagnosis, we find that not only was there a grade 1 spondylo at C2, but there's also anterior slippage on flexion, which relates to ligament instability, and their work on their computer all day. That gave you a lot more ammunition to work with than just a sprain.
Absolutely. And that's why it's always good for attorneys like me to deal with chiropractors like Dr. DeCubellis, because we can expect that workup is going to be done properly and that it's going to be noted properly in the records, because ultimately we're going to have to rely on either the records themselves, narrative reports, and or testimony if we end up filing suit from your treatment provider. So it's good to have a treatment provider who can look at the big picture, rule out that the injury or that the problem that you're suffering from related to anything but the accident. Because, as the doctor pointed out, I mean, if you are working at your desk all day, it's going to be unlikely that all of a sudden, just because you're at the desk, you're going to see these types of diagnostic findings, either on film or through palpation or the examination. Typically, a good doctor is going to be able to determine that, especially when given the history of an auto accident and the degree of the impact and the direction from which the impact came and things of that nature. A good chiropractor and a good medical doctor can tell you that within a reasonable degree of medical or chiropractic certainty, the injuries for which I saw this patient are most likely related to that accident. That is essential in order to make that causal connection to establish both liability and the damages. So, you can't have any success simply by proving that someone was negligent, right? If it doesn't matter if somebody ran into you and they're clearly at fault, if you can't show that the injuries you suffered are related to that accident. And that's where it's crucial to have the right treatment providers, not only because we want to make sure you are getting taken care of medically and or physically so that your injuries are properly treated and handled, but also so that your injury case can get you the kind of compensation to which you're entitled, and which you frankly need in a lot of instances, because they're obviously we run the gamut as far as the severity of injuries. It could be something that simply causes discomfort and maybe causes someone to miss work for a few days, to someone who is completely unable to work for the rest of their life, and that means lots in the way of lost wages. Medical bills might continue to mount up. You need and are entitled to compensation to take care of you and or your family if you're a breadwinner for the family.
Yeah, definitely. And this is one area where I've noticed that a lot of docs that either patients come in and they've seen previous, or docs that I work with, they need to understand that initial exam is so key, because we have to go over a couple different things. We've got to talk about the mechanism of injury. How did the accident cause this, or did the accident cause this? We got to look through all those different factors. Were they wearing a seatbelt? What were the conditions of the road? Where was their head turned? Were they looking straight ahead? Arms on the steering wheel? Did the airbags deploy? How far did the car move? What was the weight of the car that they were in versus the weight of the car that was impacted them? All these different things are so important when it comes to physics, but also when it comes to their injury. But another key part is when it comes to pre-existing. A lot of doctors are afraid to talk about pre-existing, which doesn't make any sense. It's okay that they had an issue before. We just have to compare and contrast the issue to how it has changed, how it's gotten more severe, and what the difference was, because then we just take that argument away from the insurance company before they even make it.
And that's a great point, because a lot of times the insurance company is going to want to say, oh, well, listen, we didn't cause this injury. They already they've been treating this malady or this problem for some period of time. We're not going to compensate for that. Well, they're right. They're not going to compensate for that. However, they do need to compensate for an aggravation to a pre-existing condition. So as the doctor mentioned, if you've got the right treatment provider, they can compare and contrast, well, what was this patient's condition before? What were their subjective complaints before? What did our objective findings reflect before? What was the treatment schedule before? Versus now we got this intervening action, this accident that happens. What is it like now? What are they complaining of now? What's the degree of severity? What more do we need to do in the way of treatment to address that? Those are the things for which the insurance carrier, on behalf of the responsible party, needs to compensate you going forward. So again, crucial to have the right treatment provider, and also obviously to have the right attorney to be able to discern all that for you. Another thing that I should probably mention regarding both the right treater and attorney is, I'm presuming if you are watching this, you have an interest in either seeking chiropractic care and or hiring an attorney related to an injury. If that's the case, make sure also that your treatment provider is attentive and is listening to what you have to say, okay? And you want to make sure that they are entering that information in their records. Because as an attorney, it's often the case that we hear a client say, yeah, I told the doctor this, or I told the doctor that, and we don't see it reflected in the records. That's so crucial, so that we can make sure that when we present the case, everything is consistent. The other thing that's important is find an attorney or a law firm that's not going to require you to do any running. You are injured. You focus on getting better. Let the attorney do what's necessary. Let the attorney deal with the insurance companies. Let the attorney order the records, order the medical bills, have the discussions with the treatment providers that are necessary to prove your case. If you got the right law firm, they should be doing all of that for you, and you should be focusing simply on getting better.
Yeah, definitely. Now, one thing I was looking at too, when we talk about this, and you brought up a good point about making sure the providers write everything down. One thing that I always make sure that I tell patients is when we're going through treatment, or anytime we fill out forms like duties under duress or loss of lifetime enjoyment activities, do not downplay it. We don't want you to overplay it, but I don't want you to downplay it either, because I take what they say at face value. So if they come in my office, I say, how are you feeling today? Oh, I feel pretty good. I'm feeling good. And then 2 weeks go by and you say, well, I don't think I'm getting any improvement. Why are you telling me you've been doing good and rating your pain low each visit? You need to tell me that right away, because this way I can either do another test. I can refer you to another doctor. We need to know, because again, I'm here to help the patient, but I can't help the patient if they don't give me the information.
And that's a great point. It's going to sound probably sappy and trite, but honesty is the best policy. As the doctor points out, you don't want to belabor things and make mountains out of molehills, but you also don't want to downplay things. You want to accurately report what is going on with your body, what is going on with your treatment, your recovery efforts. You want to properly record your level of pain and any instability that you're suffering from, any loss of motion, any of those types of things. You need to report that accurately, or else it's not going to be reflected accurately in those records. And then the attorney is left what's in those records. Even if you've expressed something differently to the attorney, if it's in the records, that's what the doctor's going to have to go on. And ultimately, if the doctor has to testify, they may not have a specific recollection of every time that they met and treated you. They're going to rely on what's in those records. And if you have not given them an accurate report, then that report is going to downplay or overplay your hand as far as explaining the extent and nature of your injuries. So certainly be as honest and open as you possibly can with your treatment providers.
Yeah, definitely. And one thing too, whenever we're dealing with these types of cases, I think it's very imperative to, especially coming from the doctor perspective and coming from the attorney's perspective, is we want to make sure that we're utilizing the right expert at the right time. So it's sometimes, a lot of times, it's not a case that I can handle alone. So this is why I enlist the services of an orthopedic surgeon or a neurologist, physiatrist, pain specialist. They all have their specific thing. And I would much rather, if we have a patient who has radiculopathy after an injury, let's send them to the neurologist, get the NCV EMG test done. This way we can either show, hey, they do have a nerve damage or they don't have nerve damage, and it's something that can be treated. But then we know this way everyone's crossing their T's, dotting their I's, but the patient's also getting the best care possible. And the other thing that's really important with that is when you're co-managing with other doctors, it's so important to make sure everyone's on the same page. Because a lot of times what I find is if I send a patient out with a doc that I'm not as familiar with, when we come back, they have a diagnosis that is in essence the same exact thing that I have diagnosed them with, but the wording is a little bit different. And we don't want it to be completely off to where it's going to confuse anyone. So at that point, I can then call the doctor and say, hey, I just wanted to find out why you found this, what's going on. Because also sometimes what happens is, especially if we send a patient out for a referral, or send them to the ortho, and they've already been treated for, let's say, 2 weeks, they've been treated in my office, their primary complaint has improved. So when they go to the ortho, they talk more about their secondary or tertiary complaint, which is 100% fine. But now that diagnosis is reflective of the secondary and tertiary, not of the primary. So we just need to work together to know that, hey, this is where they're at this point, and make it crystal clear for you. That way you're not getting these notes from all these doctors saying all these different body parts are injured and different diagnoses. And you're like, what's going on here?
Yeah. And I think those are some great points that you've raised here. As I often say, and you've heard it said in other contexts, but in this context, it's also true. It takes a village. You need, when you have especially a complicated medical, and maybe you have a complicated pre-existing medical history, or maybe you simply had injuries to a lot of different portions of your body from this particular accident, you're going to probably need care from a number of different types of treatment providers. That could be chiropractic, it could be neurology, it can be orthopedic, it can be all those things that the doctor mentioned. And it's important that these guys and women all cooperate with each other and are able to talk to each other, able to explore with each other the full extent of what each treatment regimen is attempting to accomplish, and that by doing that, then dealing with the legal end of things, reporting to us in a way that we can get, see some kind of cohesive approach to the treatment of this individual. That'll allow us a better means of reciting what the big picture is, and by doing so, then know what the expectation should be for a reasonable level of compensation. So, you want to have the right treatment providers. You want them to you want to know that they are networked with the folks that you might need to also treat with, that they will cooperate with each other, that they will collaborate with each other, and that they're also going to cooperate and collaborate with your legal representative.
Yeah, definitely. Well, any other tips or things that people should know that we haven't talked about? I mean, we've covered a lot of stuff.
Yeah, we've covered a lot. I'm sure there's a lot more that we could cover. I'm certainly always available to speak to anybody that has specific questions. They can reach out to us, at vlaw.com. That's our website, and our phone numbers there, and we represent people throughout the country. Primarily in Illinois and Iowa, but we're happy to answer questions about injury law. Anytime someone has, an issue, they can also email us or message us on Facebook. We're at Vandergans Law on Facebook. But as I mentioned earlier, we're not here to solicit cases or plug ourselves. We're happy to help. We'd be honored to help if we can. But the most important thing is making sure you're getting the right treatment. So if you're checking this out, hopefully you will consider seeing Dr. DeCubellis if you need chiropractic care, and that you get the right legal help, someone that focuses on injury law and can assist you in the ways that we kind of outlined.
Definitely. So I want to thank everyone for watching. Contact information for everyone is down at the bottom, so you can see it there. Reach out if you have any questions for me or if you have any questions for Dennis. We're here to help, but I hope you guys got some value out of this.